Hello and welcome to the Minimum Competence episode for Thursday, August 6, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, the U.S. has refunded $100 billion in tariffs the Supreme Court threw out. Big Law's entry-level hiring slumps as AI eats junior work. New Mexico sues for the Epstein files. And OpenAI asks a judge to toss Apple's trade secrets case. Let's remember, the vote is the most powerful instrument ever devised by anyone for breaking down injustice. And read today's legal news. On this day in legal history, August 6, 1965, President Lyndon B. Johnson signed the Voting Rights Act, arguably the most effective civil rights statute in American history. Johnson signed it at the Capitol, and after a ceremony in the Rotunda, he moved to the President's room near the Senate chamber, the same room where Abraham Lincoln had signed a bill freeing enslaved people pressed into Confederate service. There he was flanked by congressional leaders, Martin Luther King Jr., Rosa Parks, and others who had fought and bled for this moment. The act was a direct response to the machinery of disenfranchisement that Southern states had built after Reconstruction. For nearly a century, literacy tests, poll taxes, and outright intimidation had kept Black Americans from the ballot box despite the 15th Amendment's guarantee. The Voting Rights Act attacked that machinery head on. It banned literacy tests, and crucially, in Section 5, it required jurisdictions with the worst histories of discrimination to preclear any change to their voting rules with the federal government before those changes could take effect. It also authorized federal examiners to register voters directly. The impact was immediate and staggering. Over 250,000 new Black voters registered by the end of 1965 alone. The significance of August 6, 1965 is that it transformed American democracy by finally making the promise of the 15th Amendment real. But it's also a living, contested statute, which is why it belongs in the news and not just in the history books. In 2013, in Shelby County v. Holder, the Supreme Court effectively disabled the Section 5 preclearance requirement, holding that the formula for deciding which jurisdictions were covered was outdated. In the years since, fights over voting rules, voter rolls, and ballot access, many of which we've covered on this show, have unfolded on the terrain of the Voting Rights Act created and that Shelby County reshaped. 60 years on, the argument the act tried to settle is still very much open. A court filing has revealed the striking scale of the aftermath of one of the biggest separation of powers rulings in years. The U.S. government has already refunded about $100 billion in tariffs that the Supreme Court struck down. According to the filing in the U.S. Court of International Trade, roughly $100 billion in refunds, that's duties plus interest, had been completed as of the end of July, representing more than half of the $166 billion the government had collected under the invalidated tariffs. After returning to office, President Trump used the International Emergency Economic Powers Act, a law meant for genuine national emergencies, to impose sweeping tariffs on trading partners. This February past, the Supreme Court ruled that he had exceeded his authority, holding that the IEEPA doesn't hand the president that kind of open-ended tariff power. Now the bill is coming due, and the refunds go to the importers who paid the duties in the first place. There's a direct line from this story to one we covered last week. After losing the IEEPA tariffs at the Supreme Court, the administration reached for Section 338, a dormant 1930s trade statute, to hit Canada, a workaround that itself invites fresh legal challenge. The significance is a vivid $100 billion lesson in the cost of executive overreach. When a president stretches a statute past its limits and the courts say no, the consequences aren't abstract. They're measured in massive refunds and a scramble for new legal authority. It's the separation of powers with a price tag attached. New data shows that entry-level hiring at the country's largest law firms has fallen, and the reasons say a lot about where the profession is heading. According to the National Association for Law Placement, firms with more than 500 lawyers pulled back on hiring associates straight out of law school, and for the first time in memory, those firms brought in more lateral associates, attorneys with prior experience, than fresh graduates. Laterals made up about 49% of associate hires, while entry-level grads fell to roughly 38%, a sharp drop from the 46% share they'd held. Three forces are driving this, and the middle one should get your attention. First, clients increasingly want sophisticated, autonomous counsel who can hit the ground running. Second, and this is the newsy part, artificial intelligence is absorbing exactly the kinds of tasks that used to be assigned to first-year associates. Stuff like document review, initial research, and first drafts. Third, there's a deep pool of experienced lateral talent available to poach. The significance is both immediate and long-term. In the short run, it's a harder market for new graduates entering six-figure debt into a profession that's hiring fewer of them. But there's a real structural risk the report flags. The junior associate years are how firms train the next generation of partners. If AI hollows out entry-level work and firms stop hiring and mentoring juniors, they may find themselves a decade from now with no mid-level talent to promote, having automated away the bottom of the pipeline that feeds to the top. It's a preview of a question every knowledge profession is about to face. New Mexico has sued the U.S. Justice Department for access to the unredacted files on Jeffrey Epstein, accusing the federal government of stonewalling the state's own investigation. New Mexico's Attorney General Raul Torres reopened the state's Epstein investigation earlier this year and requested the unredacted federal files to identify people, visitors and staff at Epstein's Zorro Ranch property in New Mexico, who allegedly participated in or witnessed crimes. The state says the DOJ reneged on a 2019 arrangement under which New Mexico paused its own probe and turned evidence over to federal authorities in exchange for continued information sharing. The Justice Department counters that under the Epstein Files Transparency Act and protective court orders, it is neither required nor permitted to disclose victim identifying information, and that New Mexico has offered no lawful basis for such sweeping disclosures. Torres put the stakes plainly. The state says it needs to see those files before it can decide whether to charge anyone. The significance is a genuine legal collision between two legitimate interests. On one side is a state prosecutor who says he can't do justice, he can't bring charges, without evidence the federal government is holding. On the other are real statutory and court ordered protections for the privacy of victims, which exist for good reason in a case defined by the abuse of young women and girls. It's also another chapter in the long running politically charged fight over transparency in the Epstein files, an issue that has repeatedly surfaced around this administration. A court will now have to weigh a state's investigative need against federal victim protection rules. And finally, OpenAI has asked a federal judge to throw out Apple's lawsuit accusing it of stealing trade secrets, a case we covered when Apple filed it back in July. To recap, Apple alleged that OpenAI misappropriated its confidential information to jumpstart its own push into consumer hardware using former Apple employees, aggressive recruiting, and supply chain connections. In its motion to dismiss, OpenAI calls the allegations baseless and makes a pointed argument. Quote, OpenAI has no use, need, or desire for Apple's trade secrets, its lawyers wrote, insisting it's, quote, building something entirely new and different from anything at Apple. OpenAI's core defense is to reframe the story, not as theft of secrets, but as ordinary competition for talent. It says its real interest is in recruiting top engineers, many of whom simply chose to leave Apple for more exciting work. And that reframing goes right to the heart of trade secret law. Hiring a competitor's employees is completely legal. People are free to change jobs and use the general skills and knowledge they've built. What's illegal is taking or using the former employer's specific protected confidential information. So the whole case turns on which side of that line the conduct falls: lawful talent raid or unlawful secret grab. The judge is set to hear arguments on October 1st, and OpenAI faces an August 17th deadline to respond to Apple's request for a preliminary injunction. The significance is that this is shaping up to be a marquee test of where the law draws the line between competing for people and stealing their knowledge, a question that will define a lot of fights in the upcoming AI talent wars. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow. And until then, remember, sunlight is said to be the best of disinfectants.